Hi guys. Today we're going to talk about a retainer agreement and what the retainer agreement should entail. Otherwise, if not, it will be voidable and attorney can only collect a reasonable rate. And what's reasonable will be decided by the court. So when entering into attorney-client relationship exceeding $1,000, retainer agreement should specify the amount it's going to be billed, how it's going to be calculated, hourly rate, services performed. All of it has to be described. So, for example, my retainer agreement explains all of that, the scope of work as well, and the increments, how the billing is going to occur. For example, minimum 0.2, which is 12-minute tact at my hourly rate. I also have a structure 9 to 5, what if 5 after 5 p.m. and weekend rate, rushed rate. Everything is very specifically described. So when client enters into this written agreement, it's very clear what to expect. Typically, lawyers bill every billing cycle, meaning every month. I prefer to bill weekly so the client has transparency and can adjust the pace of their divorce based on the budget they have for this particular month. So when client is terminating a relationship or not, the lawyer must provide his or her billing statement within 10 days upon request. Exception, when already provided within the last 31 days. Then the lawyer has to provide within the next 31 days. So now we have a situation where there are exceptions. Exception meaning the retainer agreement does not have all these. So the retainer agreement is voidable, meaning it doesn't specify everything we just described. And the exception, when it's still enforceable, when it's a corporate client, when attorney performs an emergency service, when there is no retainer at all, but it was a retainer before. For example, a client hired a lawyer for preparing divorce, and then post-divorce 2 years later, the client asks the lawyer to perform a modification type of request, and then it's called implied fees, or the same fee structure applies to this case. Client is also allowed to waive the written fee agreement, and that's all for exceptions. Now, let's talk about when the fee is considered unconscionable. And unconscionable, translated, means unfair, too high. And it's described in Code Section CRPC 1.5a. And the definition of unconscionable is exorbitant, wholly disproportionate to service, shock to the conscience on the level of fraud. So it doesn't mean that if a lawyer charges a higher rate than another lawyer with the same type of experience in the community. It has to be at the level of fraud. I don't know, $5,000 per hour for a project that costs $300. That is shocking to any mind. So there was a case where a lawyer charged $3,800 for a service that typically any lawyer in the community would charge $300. So that was considered unconscionable. So, for example, if a lawyer asks for services that wasn't performed, there was a case where a lawyer charged $1,000 for appeal that he or she didn't do. That was considered unconscionable or illegal fees, meaning no service rendered, but still ask for the money. A lawyer is not allowed to ask a client for testamentary gift unless they're related. For example, I have money, I understand, so why don't you write me $1 million will so I will work. That's unethical. Now, more common than not, we have a situation where a client cannot afford, but a family member would be able to pay for it, or opposing side, and it's called a third-party payment. In those cases, So the ethical way to do it is the third party is not to interfere with the representation, meaning third party cannot dictate how to represent this client. Third party is not allowed to confidential information unless the client waives and gives written consent for the third party to pay and says, I'm okay with either waiving my confidentiality or not. Typically what I do, I have a document that both of them sign that the third party is not going to be able to interfere, or my client is not waiving confidentiality just because they pay. And then the client can decide case by case interview or meeting by meeting whether to include the third party into the meeting. Usually it's family members who help and they want to be involved. And that's where it's very important to pay attention. And also in prenup cases, right? So if I'm representing wife, husband who is defending a prenup, then and the other side wants the prenup because they want to protect their asset, they're usually the ones who pay. That's important. I would prefer them to pay the client and the client pay me instead of them paying me directly, so that I don't have to prepare and have them sign a waiver. So, duty to return unused funds. A lawyer cannot keep funds unearned, meaning if the service performed, the lawyer ended the representation or particular task, and a client terminates attorney-client relationship, a lawyer must return whatever is not earned. And a lawyer also is allowed to create the retainer agreement for fixed rate. And in that case, it has to be very specific what it's for. So, for example, drafting the stipulation, but the lawyer has to specify email communication need to be including this flat fee or not. So it has to be very specific what's included and what's not. I hope that was helpful. I will see you soon. Bye.